Those are the most common ones. For the L visas are intra-company transferees, and they have different ones, but let's talk about the L1A. And that is when there is someone that is going to be transferred as an executive in an executive or managerial capacity. So it's required that there is a foreign entity and there is a U.S. entity, and that's where the worker is going to get transferred to, the U.S. entity. And those two companies, the foreigner and the U.S. entity, must have a relationship, to put it in a way. So it has to be a branch or a parent, affiliate, subsidiary, and the person that's going to get transferred has to be, or we need to show, or the applicant must prove that the employer that is being transferred worked for that foreign entity for at least one consecutive year for the past 3 years before filing the application. And it's important to determine what were the duties, what were the specific duties, and how many people that person was supervising or overseeing. Because remember, this is an executive position, and the company that's going to be here in the U.S. can be a startup company or can be an established U.S. company. But the executive is not supposed to do the day-to-day activities of the business. So, of course, you're going to require, or the employer is going to need employees, it's going to need staff, and everyone needs to be on payroll, and there's a lot of other requirements. But the most important thing is that there are two different entities. One is the foreign entity, the other one is the U.S. entity, and the employee is being transferred. So it can be an employee, or it can be even the business owner that wants to move, direct and control the company here in the U.S. Because maybe it's a small entity, so they don't have 100+ employees, but it's the business owner himself or herself who wants to get transferred, and that is allowable. That is possible. For it's called the E classification. There are the same way as the L has L1A and L1B. The E visas also have E1, E2, E3. The E2 visa, that is for investors. And in that specific visa, the investor, the entrepreneur, wants to invest a substantial amount of money into a business in the United States. Then the difference with the L visa, there is no requirement of two different entities, the foreign entity and the U.S. entity. For E2, the investor just puts his money in a U.S. entity. And it's important that the investor is from a country, the United States maintains a treaty, and those are specific countries. So if the investor is a citizen of that country and invests a substantial amount of capital into the business, then it may be authorized to apply for an E2 investment visa.
The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.